Brehon Law was the legal system practiced in Ireland for over 1,000 years until the Norman invasion. This was based on customs, not state legislation. It operated on the island until the 17th century when it was replaced by British common law. Brehon Law was not centralised. It was taught and then applied locally. Brehons were legal scholars and arbirators, mediators. They helped you find justice and fairness. It wasn't a fight. Brehon Law was restorative. You didn't punish people. There was no prison. There was no police. Brehon Law focused on compensation and restoring social balance. Offenders of a crime paid the eric, the honour price, to the victim's family. Fines varied based on the person's status, the severity of the crime, and your intention. Individuals were not legally autonomous the way they are in common law. The responsibility extended the fine to your family, so your clan would have to pay the debt. The law aimed to prevent escalation by restoring honour and avoiding blood feuds. This was a status-based society. Your rights and responsibilities within the society were tied to your rank and your wealth and your reputation. So there was High King, this is Brian. My granny was O'Brien. He was the High King. Then you had kings, they'd meet in Naas. Then there was the nobles called Ara. Then there was free commoners and not free people. Quick reality check about Brehon Law, because anytime you talk about pre-colonial systems, people just assume that you're romanticising the past. Yes, there were slaves, there was hierarchies, it was a class system. In Ireland though, class was explicit. The structure of law was not designed to extract wealth. It was like medieval times. We have evolved, but we still live under a viciously exploitative hierarchy. In Brehon Law, responsibility ran both ways. The nobles owed duty down the chain as well. Modern law pretends that everyone is equal, but it exists to protect property, of which people are considered. Common law never evolved out of feudalism, it just globalized it. And questions about why Ireland had slaves distract from the conversation this video is trying to have about why your landlord in 2025 is still extracting half your wage. So the land under Brehon Law was held by the Tua, your clan. Individuals held use rights, not privately owned, and the land was redistributed regularly among the communities, deliberately to avoid landlordism and land accumulation. The legal frameworks were focused on governing like grazing rights, seasonal usage, boundaries, conservation, disputes. Under Brehon Law, if land wasn't used properly, like you were sitting on empty property, your rights got reverted back to the community. The people creating and enforcing Brehon Law had completely different priorities and presumptions about what law was supposed to be doing compared to those who enforce English common law. The Tua had assemblies where they agreed social obligations centrally and then went back to the community with the priority of preserving harmony, protect collective access, ensure the reputation, honour and fairness of the family, resolve disputes through negotiation where at all possible, and maintain ecological balance. English common law and the people who defend it, lawyers and politicians, are focused on protecting private property, establishing ownership, controlling the poor through vagrancy laws, enclosures, fencing, and punishing disobedience to the Crown. The focus of English common law is to ensure perpetual and in perpetuity productivity under elite control. Brehon governance was about keeping the peace between neighbours. Common law is about keeping control from above. Women could own property. They could inherit and initiate divorce. There were 7 forms of marriage, each with different economic and legal implications. It recognized that different people's different relationships had different requirements. You could have a marriage of equal contributors. Both partners share equally the wealth and status, most common kind of marriage. You could have a marriage based on the man's contribution. The wife is joining that household. Or you could have a marriage based on the woman's contribution, where the wife is bringing the wealth and the man contributes very little. At least you're acknowledged for it. You could have a marriage for love based on mutual affection, so not a property arrangement. There's law for cases where a man elopes with a woman's wealth. They had a structure to return that to her. You could also formalize your friend with benefits, mostly if there was children involved, as a formalization for compensation. But it is literally referred to in Irish as the union of sexual intercourse. And you could have a secret marriage where the family didn't approve, but there was still some level of legal recognition for inheritance rights. These are all documented in the Con Lamana in UCC. And the divorce could be sought for a number of reasons: abuse, impotency, infidelity, or failure of duties. Legal codes regulated professions. Doctors, poets, smiths, like workers, people who make things, and foster parents were regulated professions. There were set fees, duties, and penalties for any misconduct. The people held in highest regard in Ireland under Brehon Law were the Brehons and the poets, like above nobility. Poets were so important because knowledge is power. Communication is the law. Memory is governance. Poets were not elite because of their birth. They were elite because of their skills and training, their wisdom with language. They weren't just rhymes. It was historians, genealogists, record keepers, advisors to rulers. They preserved the oral tradition, the social contracts. A fair society demands clarity. We have to share education. If people don't understand the law, how can it function? Locking it away in Latin jargon is just domination through confusion. Poets and Brehons existed in ancient Ireland to prevent your rulers from lying to you. Colonial law doesn't fear crime, it fears clarity. A population that knows its law cannot be ruled like slaves. There are Brehon laws around bees, fishing, water, even cutting sacred trees. Chopping down an oak tree carried a heavy fine. This law had ecological ethics. 1169, the Normans made it over, and in parts of the country they coexisted for a while, but eventually English conquest and the flight of the Earls officially outlawed local indigenous law, and the final collapse of the system came with the introduction of the penal laws. But there is a lot that can be learned from key themes of empower and educate people and then decentralize it. Come together to unanimously agree and form collective understanding. Elevate people who proactively keep the peace within their roles. Celebrating learned, educated wisdom. Keeping communal land in community holdings and have ecological regulation. It provides the West with some kind of a non-colonial structure to inspire future waves of decentralized, trust-based community governance and upholding Indigenous rights.